All rise. Court of Appeal, Division 1, now in session.
Thank you all. Please be seated. Good morning, everyone. This is the time set for oral argument in Colton Health versus Arthritis Health. Our case number is CACV 22-0041. Each side is allocated 20 minutes. Appellant, you may reserve a portion of your time for rebuttal. If you choose to do so, you'll need to keep track of your own time at the clock at the podium. Out of respect for counsel and to avoid any avoidable embarrassment, I would ask those in attendance to make sure your phones are turned off or muted so our proceedings aren't interrupted. Our proceedings are being recorded, being posted to YouTube at an appropriate time. As you begin your argument, please therefore state your name and the party that you represent. With that, Mr. Kitchen, you may proceed.
Good morning, Your Honors. Michael Kitchen with the firm Sachs Tierney for the appellants, Colton Health and Suki and Kieran Gimman. I'd like to reserve about 8 minutes of time. I'll keep track of it. So this case involves the purchase by the appellants of the appellee's rheumatology practice in 2018. The rheumatology practice was sold. The appellants purchased it for a purchase price of $500,000. $200,000 of that was allocated to equipment. $300,000 of that was allocated to goodwill. Goodwill was the primary asset that was purchased. What was the goodwill? The goodwill was essentially the reputation, the relationships that the doctor had created with his patients over many, many years. That was what was being purchased. There were representations made at the inception that the reason it was being sold was that the doctor wished to retire at the conclusion of the, there was going to be a period where he was going to be working as an employee. Then there was going to be a period thereafter where he was going to be working as a consultant. The understanding was that he was intending to retire after that time. So the purchase occurred, a purchase agreement was signed, an employment agreement was signed. Subsequently, the contemplated consulting agreement was signed. It was extended a couple of times. And in 2020, specifically August of 2020, there were various disputes that were occurring at that point. The doctor indicated that he wished to leave the practice of Colton Health, and he indicated that he was intending to, notwithstanding what was told previously, start up a new practice where he was going to be servicing patients. There were a number of emails that occurred in August of 2020. So, and there were other emails around this time. These are the critical emails that I think Your Honors have seen that have been attached to the appendixes in this case. And on August 16th, he indicated that he wants to make plans for leaving Arthritis Health. I would like to know what story you want the staff and me to tell existing patients and how to tell them. Do you or I generate a letter to patients, and what do we tell them when we're in the office for the next 6 weeks? I will be setting up a limited practice to see patients outside of all insurance as of October 1st, 2020, if we cannot agree on a sublease. Now, in the appellee's papers, the appellee has focused very heavily on if we cannot agree upon a sublease language and indicated this was just a, the parties were just negotiating about the terms of the leaving of the practice. That's actually not correct, though. So, again, on the same day, Suki Guman, who was one of the appellants in this case, indicates he's talking about the plans to leave. However, it is the losing patients aspect that concerns me. The parties were discussing this. It was clear that he was going to be taking certain patients with him. Suki Guman put that in.
Counsel, where is that clear?
What's
and I'm struggling with how that is a breach, because I go back to the terms of the agreement. And the terms don't say he cannot treat other patients. The terms say he has to give notice to the patient, that he has to give notice to the company, and that he won't treat it unless the company gives permission. Where does he say he's going to do any of those things? Or that he's not going to do the things he must do, and that he will do the things he's not allowed to?
So it's paragraph 16, section 16, the third paragraph of the consulting agreement, specifically addresses these issues. What that provision says is that for a period of 1 year after the doctor leaves, he is not to do anything with any of the existing patients. Okay? Now, typically in a typical employment circumstance, that would be unenforceable, but this is not a typical employment circumstance because this was the purchase of a medical practice. So the Farber case and all of the other lines of cases following Farber don't apply because the Farber case specifically exempted purchase of medical practice situations from its holding.
Well, counsel, this is a physician's consulting agreement. This is not a sale agreement.
Yes, but the physician's consulting agreement was specifically referenced in the sale agreement. It was part of the sale transaction.
Not this one. This is a subsequent consulting agreement. This is not one that was referenced within the sale agreement. It didn't even exist.
In paragraph 17 of the purchase agreement, it specifically refers to consulting services. So the consulting services was a part of the purchase transaction. That was part of the transaction. The doctor was going to sell the practice, was going to work as an employee for a certain period of time, and then thereafter was going to work as a consultant for a certain period of time. And that is again referenced in paragraph 17, which I think is A-426.
And that was 2 consulting agreements ago.
Well,
because this is the third one.
Well, I think the consulting agreement was simply extended several times.
Counsel, where would I get that from the April 6, 2020 physician consulting agreement that it's merely an extension?
I don't think it necessarily says that in the agreement itself, but again,
I don't recall that either.
If you look at the consulting agreement in connection with paragraph 17 of the purchase agreement, it's clear that they were all part of the same transaction. The consulting agreement was a condition for the purchase of the practice.
The initial sort of 5-month period consulting agreement, right?
And again, it was extended a couple of times. That is correct.
Well, there are 3 consulting agreements. Whether they're extended or not turns on their terms. Would you agree?
I think it turns on the circumstances. And in this case, under the circumstances, Colton Health was having trouble getting another rheumatologist to take his place, and so there were a couple of extensions. But again, that was contemplated in the sale of the practice.
So your position is the consulting agreement that was dated the 5th of April 2020 was part of the contracts that were executed in September of 2018?
They were specifically contemplated in those contracts. That is our position.
And I'll look at paragraph 17. I'd be sort of surprised if it listed a contract that wouldn't exist for another 18 months?
I don't think it lists the contract by date, but it does indicate that he was to provide consulting services for a period of time.
The terms weren't laid out, though, either, of what that consulting agreement specifically would look like.
That's true.
Okay. And they could have changed. I mean, you were open to negotiating when you say they rolled over, essentially. They could have been, you were calling them extensions, but they could have contemplated different terms, the second one or the third one. There was no restriction in paragraph 17 of the purchase agreement that they had to remain the same or what the provisions would be.
That is correct. That is correct.
So, counsel, is it your position that is the breach? I want to understand exactly when you say the breach occurred.
August 17th, 2020.
With that email?
So, no, it was the subsequent email, and I was about to get to this point. So in response to Suki Guman's email, it is the losing patients aspect that concerns me. So there was clearly indications that patients were going to be taken on August 17th, 2020.
Wait, who wrote that email?
Suki Guman wrote the email saying it is losing patients aspect that concerns me on the following day.
Okay, so the doctor didn't do this. Guzman expressed concern that it might happen.
That is correct.
So how does a concern by one person create a breach by the other?
So on the following day, on August 17th, 2020, Dr. Howard indicated, in response to that email, a day after Suki Guman sent that email, I feel like we should make my plans for leaving Arthritis Health. I would like to know what story you want to tell the staff and for me to tell existing patients and how to tell them. I will be setting up a limited practice to see patients outside of all insurance as of October 1st, 2020. And in the August 17th email, this whole discussion about whether we can agree on a sublease or not was not there.
Okay, so, he says, what am I going to tell the patients, because he's leaving the practice.
That's correct.
And then he says, I'm going to set up a separate practice. Where does he say, my plan is to take some of your patients? He doesn't.
So,
in fact, he says, I'm going to take my patients are going to come in a wholly different way because they're going to have to self-pay.
So there are two aspects to the claim for breach in this case. One is non-solicitation. So a non-solicitation in the context of a sale of a business, there's really no deadline. That can go on for essentially...
Let's focus in the terms of a physician consulting agreement.
Okay.
Because I think that's probably where you want to put your energy. In the terms of a physician consulting agreement, where's this non-solicitation approach?
So it's not even a non-solicitation. Again, it's the third paragraph of Section 16 specifically indicates that he is not to do any business whatsoever with any patients for 1 year after leaving. That's what it says. And that was agreed to. That was agreed to, again, in the context of this sale of this practice.
And your client was concerned he was going to do that?
Pardon?
And your client was concerned he was going to do that?
Well, it was clear he was going to do that to my client from the emails. So
Okay.
in response to the email, I'm concerned you're going to be taking our patients. How did Dr. Howard respond? Did he respond and say, don't worry about it, I'm not taking your patients? No. He said, I'm going to be letting the patients know I'm leaving, and he didn't even mention the fact that Suki Guman was concerned. So I think this is not even an implicit
Let me ask you a
anticipatory
question
breach.
in terms of breach by your client. Did your client pay the August 30th payment under the physician's consulting agreement that was due in arrears?
I think he
It's a
stopped.
yes or no question, so.
My recollection is he stopped paying in September. To be quite honest with you, I cannot remember.
Did he make the August 30th payment, or are you saying you think he made the August 30th but didn't make this, or 31st, but didn't make the September 30th? Or are you just saying you don't know?
I believe that is correct, but to be quite honest with you, I would have to go back.
Where in
to
the
look.
record would I find it?
That would probably be in one of the motions for summary judgment. Probably the motion for summary judgment that was filed by the defendant's appellees in this
If
matter.
his client said you didn't, and that's what's in his affidavit, why don't you, before you come up for rebuttal, see if you can find where your client said they did?
I will look at that, and I will look at it on rebuttal. Okay. So again, I think there are two aspects to the anticipatory breach issue here. One is there was an indication that he was not to solicit clients. Now, we have provided an extensive amount of documentation indicating what we believe a reasonable juror could find was in fact solicitation. So the position of the appellees in this matter is he didn't reach out to any of the patients. He only responded when patients wrote to him. I think that's a bit incorrect, because if you're walking down the street and someone comes up to you and says, "Hi doctor, I heard you retired, how are you doing?" and you respond with, "I'm doing fine, I have not retired. By the way, here's my phone number, here's my address, you can call up one of my people to make an appointment," that's a solicitation. Just the fact that you're responding.
Did that occur before or after August 30th?
Pardon?
Did any of that occur before August 30th?
Not to my knowledge, no, Your Honor. But again, it is our position that he indicated he was going to be doing that, which is exactly what happened in this case.
And I just want to make sure you have the document in front of you.
This will be the last question I answer.
But there was a procedure that he could service current Colton Health clients with the agreement of your client, with notice, with showing the client paragraph 16, going to you and saying they still want to service with me. The agreement contemplated that was possible.
If he was working with Colton Health,
Right,
which is not what happened.
And we're not to take this as evidence that he was attempting to work with Colton Health to abide by the agreement?
That is not what was said in those emails, and that is not what occurred. And if it's okay, I will reserve the rest of my time. Thank you.
Mr. Tobler.
Good morning, Your Honors. Doug Tobler, representing the appellees in this case. I don't have a lot to add to what is in our brief. I would remind the court what we're talking about. Dr. Howard gave Colton Health a business with 5,000 to 6,000 patients. A total of 191 of those patients left after Colton Health breached the contract by failing to pay. And by the way, you asked the question as to whether or not the payment was made for August. The answer is absolutely not. And then instead of accepting what had happened, Colton Health decided not to pay Dr. Howard $385,000 and sued him. We haven't, I don't know if you have any questions about the damages issue, but I think it's determinative before we get to anything else. The law is very clear that in this kind of case, the damages are lost profits. There's no evidence of lost profits. There's some evidence of perhaps lost revenue. Now, on appeal, the appellants argue that that's their lost profits. Well, the problem with that is that's not their lost profits. Rule 26.1 requires them to show a computation of their damages. Most businesses have costs, and in this case, the elephant in the room, they claim that they had minimal costs. Well, it was up to them to provide that.
Let me ask you about the damages.
Yes.
Now that you raised it.
Yes.
Was discovery and disclosure completed? Was it closed when summary judgment, when the motion practice occurred?
Yes, it closed on July 1st of 2000, what year was that? 21. There was no further discovery permitted, and they had not disclosed any costs or damages, including...
When were the motions filed, though?
I filed the motion in April.
Right.
And so they had until July 1st to disclose. It took them a little over 2 months after we filed the motion before they disclosed any evidence whatsoever, even about lost revenue.
Your motion raised lack of damages, and by definition, with a good faith basis for that.
Yes.
Help me better understand that, given that it was filed before disclosure and discovery had closed.
Well, they had a duty to disclose, and we sent out interrogatories and requests for production, which they objected to. They wouldn't provide those information. So we asked for it, they never gave it to us.
Okay.
So at that point, we had no choice but to raise that issue. And on that issue, they say we had minimal damages, or minimal costs. Well, again, the elephant in the room is Dr. Howard left. They had to hire a doctor or pay a doctor money to take his place. What was that cost? We don't know. And they couldn't add that at any point later. Simply stated, they have not produced any evidence of damages. And then to the point that the court was interested in about the breach, first of all, I don't know if any of the three of you think that Dr. Howard's supposed statement that he intended to retire at some date, at some time, before the contract was signed, when the contract specifically says there are no outside agreements, whether or not that could be an issue. But if so, when? When was he going to retire, since they continued to hire him to perform services? There simply is no evidence from which a jury could find that there was an enforceable agreement with specifics as to the fact that he would retire. So that issue really doesn't exist. And then we go to the breach.
So it would have to be a more specific that his intent was to retire when he finished, as they would put it, renewing physician consulting services agreements with them.
Yes, and if you look at the emails in August, even in August, Mr. Gooman wanted him to continue. So that date hadn't yet reached, hadn't occurred at that time. And then we get to the issue of breach by anticipation.
Would you agree that it was a continuance or a renewal? Or is your position that it was an entirely new physician contract?
Each one of those contracts is a new contract. They were all negotiated. None of them refer to the other ones. They're all new contracts. And then we get to the question of breach by anticipatory repudiation, an issue that was never raised in the trial court. It was never pled.
Is it anticipatory repudiation or is it prior material breach? Because those are different.
Well, I think they're saying the prior material breach was a breach by anticipatory repudiation, so I'm not sure they're different in this case.
And prior material breach was raised, right?
If you look at their response to the motion for summary judgment, they do not actually argue that. They argue that the breaches were the solicitation, which occurred long after they stopped paying. I don't think it's raised in...
I thought there were some filings attaching a lot of email correspondence back and forth. Now, perhaps your knowledge of the record, including the August 17, August 16 exchanges.
Yes, but they never said that that was a breach. It was never pled, never argued. It was never raised. The trial court never had a chance to look at that, and we never had a chance to take discovery on it. That's the reason for the rule that we don't consider things first time on appeal.
Let me ask you about that, though, because there were minute entries in two waves, right? There was a motion for summary judgment on count 5 of the counterclaim that
Yes.
was resolved pretty
Yes.
early by a different judge, and then the sort of big motion, if you will, omnibus
Yes.
motion was resolved by a different judge later. I recall that minute entry talking with some precision about material breaches and prior material breaches. Perhaps I'm misrecalling that.
I don't recall, to be honest with you. But if you look at the record, they didn't raise the issue. They simply didn't. If they had, we would have argued it. And if we'd argued it, we would have come up with the Arizona cases that say that in order to become a breach by anticipatory repudiation, there has to be an unequivocal statement that I intend to breach. That simply doesn't exist here. You can't do it by implication. Arizona law is very clear on that. And here, all Dr. Howard ever said was that he intended to open a practice, which, as we go through thoroughly, he was able to do. There was no, and he wanted to, he basically wanted their blessing on it. And the response shows you that they didn't consider it anticipatory repudiation, because Mr. Gooman says, let me mull that over. That isn't what someone says when they think you breached the contract.
Perhaps upon mature reflection, they might, after saying that.
Well, perhaps, but then if they really believe that, why wasn't it in their complaint? And it's not. You can look at the complaint and the amended complaint. There is no claim that there was a breach by that email. And I give appellant's counsel credit for coming up with an argument now that was never raised before, even though I don't think it has any merit now, but at least they thought of it. There is nothing in that email that says, I'm going to solicit clients. It simply doesn't exist, and that's the only potential breach. The idea that the consulting agreement, which, as you pointed out, is not part of the sale contract, it's a year and a half later, could be enforceable to keep a physician who was working as an independent contractor from doing anything for anyone who had ever been a patient of Colton Health simply flies in the face of Farber. As I point out in our brief, according to its terms, it would keep Dr. Howard from mowing the lawn for free for anybody who had been a patient. That cannot be enforced. It's never been enforced by any court in this country as far as we could find. It's simply, that simply is not a breach. Dr. Howard was permitted to open his own practice. He did open his own practice, and they breached by not paying him. So the first and only breach was by Colton Health.
And do we just infer that that was a material breach? Because I don't know that the Superior Court ever expressly said that.
I think as a matter of law, if you don't pay someone $385,000, there can be absolutely no question.
What about the physician's consulting agreement?
He was supposed to be paid $34,500 every month. For the month of August, and it was paid in arrears. For the month of August, Dr. Howard worked full-time. When it came time to get the $34,500, they did not pay it. And on September 1st, they locked him out of the office and kept him from earning the $34,500 that he was entitled to in September. So that's definitely a material breach. When somebody works for a month and you don't pay them, there is no rational judge or jury that could find that that was not a material breach. They simply didn't pay. I don't think we even get to the question of solicitation, but I would note to the court that in the McAllister case, versus Catella, this court considered the issues here and specifically rejected dicta from other courts that had held that it was improper for a former employee to talk about their business when they're approached by a former client of the business they left, or in this case, a patient. That case simply rejects that, and as we point out, there is absolutely no evidence, because it did not happen, that Dr. Howard solicited, that he went out, that he importuned anyone to go to his business. There's only one reason why former patients would come to him, and that is because he was their doctor, and he had every right to talk about his business once they initiated the contact.
Did he do any solicitation after October 1st?
No.
So even after October 1st?
Even after October 1st, there's absolutely no evidence in the record
And
that he
when did
approached anyone.
When is the evidence in the record, just so we're clear, of the first contact by a patient that he responded to?
It was in mid-September when patients, as I point out in our brief, the patients say that they received an email blast from Colton Health, and in that email blast, they apparently said that Dr. Howard was taking a sabbatical, and patients who had his personal phone number, because he was the kind of doctor that gives that information out, then started contacting him to find out, is that true? Are you on sabbatical? And he answered truthfully that he was not, that he was intending to open up his own office in October. That, under the McAllister court, that's simply not, it's not solicitation. I would rely upon our briefs for everything else. If the court has any other questions of me, I'd be glad to answer them. Otherwise, I will permit Mr. Kitchen to respond.
Thank you, Counsel.
Thank you.
Thank you.
Mr. Kitchen.
Your Honors, counsel indicated that the issue of anticipatory breach essentially was not raised down below. I don't think that's correct. In the complaint, which is index of record number 1, paragraphs 27 to 31, specifically talks about this issue. And in one of those paragraphs, it specifically says that Dr. Howard has or, quote, has or will solicit, unquote, or will solicit. That is a clear statement of an anticipatory breach, so I think it's not correct that this issue was not raised down below.
Can
Additionally,
you give me those paragraph numbers again? You went a little fast.
I apologize, limited time.
I understand.
Paragraphs 27 to 31, index of record 1. Index of record 77, that's the motion for summary judgment, pages 9 to 10. This issue was discussed, and in the statement of facts, which is index of record 81, paragraph 11, which is part of the response, and also paragraphs 28 to 32, which is the appellant's affirmative statement of facts. So I think this issue was addressed down below, and I think it's proper to be addressed on appeal. Obviously, the court has discretion to review this issue even if it wasn't raised below, but we believe it was raised below. Counsel indicated his position that the consulting agreements were a separate contract. Each one was a separate contract. Under these circumstances, I believe that's a factual question. The Goomans are going to testify differently. This was a part of the same transaction. Now, various aspects may have changed, but it was all contemplated under the practice purchase agreement. It was the purchase of the practice that was the overarching issue here. Everything else there was just to address how that purchase was to proceed and what Dr. Howard's involvement was going to be going forward.
How does it become a fact issue if there's nothing in the contract, which is what we'd be interpreting, to say it's part and parcel of the former agreement that even refers to it?
Well, because I think it is reflected in the practice purchase agreement, and I believe, again, it's paragraph 16. I'm sorry, section 16, paragraph 3 thereunder.
Okay.
And I can read it into the record if your honors wish.
Counsel, your point is that a jury decides what constitutes the contract as opposed to the court on a State Farm versus Taylor kind of
Well, I think
analysis?
under these circumstances, when you have one party saying, oh no, this has nothing to do with what we were dealing with before, and another party saying, yes, it does, and the contract is contemplated in the original agreement, I think factual issues are raised.
But just to clarify, and I understand what you're saying, but you're saying it's the jury that makes that call, not a judge after considering evidence.
I think the judge could make that call if it was completely clear and if there was no evidence that a reasonable juror could find with respect to one of the issues. But again, I don't think that's the case here because...
What's your best case for the fact that a jury determines what is the contract?
You have me flat-footed on that. I will not be able to answer that question at the moment. So
Please proceed.
I can provide, obviously, supplemental briefing if the court wishes. Let's see here. Damages, lost profits. The opposing counsel has indicated that, in their opinion, the appellants did not sufficiently disclose damages. There were several issues. I believe a Rule 56D was filed on this. I don't know if it was filed on this particular issue.
I think it was a different issue.
I think it was a different issue, but discovery had not yet closed at this point. But the appellants did disclose the precise number of patients who were lost. I think it was 191 at the time, the precise amount of revenue that was lost as a result, and indicated that that's what they were seeking. Now, appellees indicate, well, maybe there was costs associated with it. The appellees did not get an expert to say there would be any costs associated with servicing these 191 patients.
Whose burden would that be?
It's our burden to present our damages claim, and if they disagree and if they think something is incorrect, I think the burden shifts to them. Again, they didn't provide an expert. They didn't provide any, you will not find anything in the record addressing this. And Dr. Howard was a doctor who handled this type of practice, obviously, for many decades. In his affidavits, he didn't even mention any of these issues. He didn't go through and say, well, in my opinion, 20% of the revenue should be taken off as a cost of doing business or anything like that. There is nothing in the record to support their position that the damages that were sought cannot be obtained. Now, once again, if they wish to argue at trial, we think that, the cost of additional paper to handle additional files. Because remember, the staff was in place, and my clients are going to testify that the staff was in place. The equipment was already there. The lease was already there. So what additional costs associated with it other than additional time? And that would only be relevant if you were paying the staff per hour, and servicing these additional patients would increase that time. There's no evidence whatsoever in the record to support that assertion. So I think as far as this issue goes, there are clear factual questions that would preclude summary judgment on this issue. And I don't actually think the court ruled and granted summary judgment on this issue. I know they raised the argument down below, but I don't believe this was one of the bases that the trial court chose to rely upon in making his rulings. So, let's see here. As far as the questions of the solicitation, again, there were two aspects, we believe, under the applicable documents, that the doctor was prohibited from dealing with the patients for a period of 1 year after leaving at all. And again, in the context of a business sale, that makes sense, because if you're buying the goodwill, if the person who created the goodwill at some point leaves, you don't want that person to be in any way, shape, or form interfering with the transfer of the goodwill, which any sort of business dealings might do. For example, if the doctor wanted to start competing in, say, 2 or 3 years, mowing the lawn and going around mowing everybody's lawn for free could maintain a goodwill, which is something that my clients purchased. So I think in this type of a circumstance, the typical employee non-compete situation and non-solicitation situation doesn't apply, because again, remember, this was the purchase of a practice. All of these agreements, everything having to do with this transaction, arose from the purchase of the practice, which my clients, again, paid $500,000 for to purchase this practice, $300,000 of which was for the goodwill, which was solely generated by Dr. Howard.
Counsel, let me ask you before your time expires. There's a question in your opening argument about the August 30, 2022 payment, or the payment for that work. Do you have an answer for that?
It was my understanding, and I apologize if I didn't have the answer ready earlier. It was my understanding that the alleged breach wasn't effectuated until September, so I have no reason to disagree with counsel's affirmation that the August 30th payment was not made.
Thank you. Thank you.
Thank you, Your Honors.
Thank you, counsel. We appreciate your briefs. We appreciate your argument today. We'll take the matter under advisement. We'll issue a written ruling in due course. Court stands in recess while we set up the courtroom for our next oral argument. Thank you.
I did it the wrong way.